The problem with legislation today is that it only speaks to one of three types of user groups. The Good Law Initiative has shown us that there are three main groups of legislative users, of legislative audiences. We have lay users who read legislation in order to find answers to their everyday problems and needs. We live in a Google time, and legislation is read by Google generation who are used to receiving answers straight away from the internet on any question that they might have, whether they are entitled to a benefit, whether they have an obligation, whom to go to enjoy the benefits, how they can comply with their obligations, and so forth. Legislation also speaks to non-legal professionals. And these are people who have not studied law before, but they are used to using it and practicing it in order to meet their professional needs. For example, people in HR know, without a legal background, know how to use legislation in order to proceed to contracts on employment, on compliance, and so forth. Banking is another example of this. And finally, we have lawyers and judges, and it goes without saying that they read legislation. They read it to understand it, to apply it as lay users, but also to interpret it when litigation is requested. So it is evident, I think, that the requirements of each user group are diverse. There are different reasons why each user group reads legislation, but also their level of legal and topical sophistication is different. So there is a diversity, not just in what is required by legislation, but also what level, what pitch of legal and topical sophistication it is required to have. So this depicts a picture of diversity, diversity of needs, diversity of backgrounds. And the question then is, can a single text speak to all three of those user groups? Can a single text answer the questions of three different user groups? And can it express those answers in a way that each of those three user groups understands? In the past, there was a lot of support for the plain language movement. The plain language movement is there to request or demand that legislation is drafted in a way that is easy to understand. The problem with the plain language movement is not in the concept, but in the execution. The plain language movement is by definition a bidimensional movement. It requires a bidimensional text, one that is either simple or context or complex. But I've already said that this is relative. It is relative because there is diversity in the requirements, but in the backgrounds as well of each of the user groups. The answer comes from the Easification movement. And it is the Easification movement that comes as a successor or a development of plain language that attempts to respond to the question of how can a single text achieve all this. Easification is not easy to define. My personal definition is that Easification must be seen quite broadly. It is a manner of expression and presentation of legislative communication that enhances accurate receipt by the intended audiences. So it is important to know that Easification is not only about words. Words are important in the text, but also Easification requires a structure that is easy to understand. In other words, an internal structure in legislation that guides users to the answers that they perceive. And the logic is that the less trained in legislation a user group is, the less tolerance it has of a long text. So answers to lay users should be at the very beginning of the text. Lawyers and judges, well, we're used to reading legislation. We're trained to cope with long texts. So our answers can very well come at the very bottom. So structure is an interesting internal tool for easification of a text. Similarly, presentation is very important. It does make a difference to see a text that is black, brief, against a white background, because that allows the main words, the main keywords to stand out. So even presentation is important. And finally, even the placement of the text within the statute book is equally important. Why? Because it offers users context. So if there is a piece of legislation that, on the basis of its title and content, is placed within a wider group of texts, then it conveys to even the lay user the message that this should be read as a whole with all relevant provisions. It invites the user to go beyond a single text, thus acquiring, hopefully, a holistic picture of legislation. I hasten to add that this is no replacement for legal training, and I wonder how far the understanding of lay users can go with relevance to context and the interrelation between legal texts, and certainly the involvement of case law. However, this utopian pursuit should not deter us from trying to introduce legislation that offers as much context, as much information, as much simplicity as possible in order to ensure that our legislation is read, is complied with, and ultimately enjoyed by all three user groups.